Buying and selling of bills of exchange. In terms of a trade activity, it have a right to buying and selling of bills of exchange. A bank should not employ or be employed by a managing partner as stated under section 10 of a Banking Regulation Act. A banking company shall prepare a balance sheet and a profit and loss account on the last day of a working. Hello everybody, a warm welcome to one and all. I am Mr. Hemant Kumar from the Department of Commerce and Management, Vidhyaashram First Grade College, MYSURU, the Temple of Excellence. In today's session, we are going with the subject Banking Law and Practice, Session 2 of Unit 2, that is Banking Regulation Act 1949 for first semester BCom students. This is the agenda of today's session. We are going with the concept of Banking Regulation Act 1949 Part 2, that is about business of banking company. Here in the business of a banking company topic, we are going to study about all the kinds of the business which the banking company is going to undertake, and there are some business which is prohibited by Banking Regulation Act that must not followed by a banking companies. And also we are going to go with all the activities norms of the banking companies. Right. So when it comes in terms of a part 2, that is business of a banking company, this business of a banking company, it consists of 30 sections and 12 subsections. Totally it is 42, right? So here we are going with 30 sections and 12 subsections, but it is a bulk in quantity. But we cannot go with all the 30 sections and 12 subsections. So I had hence we had chosen a important topic in the exam point of view, and we are going with only with the important topic. According to section 6 subsection 1, it is going to say about a business which can be undertaken by the banking company, right? So it is going to say about which are all the business that the banking company can undertake. Under section 6 subsection 1 of a banking company may be involved in a business of borrowing or lending money. So it is a main function of a banking company, borrow the deposit and lend the loan for the general public. So it had mentioned under 6 subsection 1 of a Banking Regulation Act 1949. Buying and selling of bills of exchange. In terms of a trade activity, it have a right to buying and selling of bills of exchange, promissory note, coupons, various kinds of drafts, bills of lading. This bills of lading is issued by a transportation company to a shipper. Railway receipts, warrants and debentures. So these are all the things that the banking company can undertake. And also buying and selling of a foreign exchange. So as we know, banking company, they do exchange a foreign currency, right? They do have a right under the section 6 subsection 1. And also it is going to dealing with the stocks, funds, shares, debentures, bonds, as we know. So it is going to issue shares, debentures, bonds. It is going to trade with the stocks, right? So there are a number of applications that is launched by a specific banking company, right? So on to which we can go with trade activities, shares, debenture. We can purchase a shares, debentures of a specific banking company, right? And also it carries a agency business. Not only banking company go with the purchase and sell of shares, debentures and bonds, but also it is going with the agency business and also conducting the business of guarantee and indemnity. So this is very important, guarantee and indemnity. Guarantee means it's a promise that is made by a banking company to cover a debt. Indemnity is a promise that is made by a banking company to compensate for a potential loss or a damage that is incurred. According to section 7, use of word bank, banker and banking or banking company, right? So according to section 7, no company other than a banking company shall use a part of its name or a connection with its business any of a word, that is bank, banker, banking. It is going to say that other than banking company, none of the company, they doesn't have any right to keep a name as a bank, banker or banking, right? So it must only adopted by a banking companies that had registered under a Banking Regulation Act 1949. And no company shall carry on a business of a banking in India unless it is uses a part of its name at least once of such words, right? So if there is any kind of a banking company that is present in India, it must keep its name as a bank, banker or a banking which is going to do a banking business. So this paragraph is going to say that if any kind of a company that had established in India, so which is not a banking company, it must not supposed to use a term bank, banker and banking in its name or a title, right? So if it is a banking company, it do have a right to use a term bank, banker and banking, right? And in the same way, it must register under a Banking Regulation Act 1949 and must also follow all the kinds of the norms and the regulations that is made by a banking company. So no firm, individual or a group of individuals shall for the purpose of carrying on any business use of a part of its or his name any of a word bank, banking or a banking company, right? So if he is an individual, if it is a group of people, it is a group of organization or any kind of a firm or a company, so they are not supposed to use a word of bank, banking and banking company on the title of a company, right? So until and unless it had registered as a banking company, they are not supposed to adopt this kind of a words. It is against the law. According to section 8, it is going to say about a prohibition of trading. So according to section A, it is going to say about a trading activities of a banking company. So it can only do a trading activities which is listed under a Banking Regulation Act 1949. It does not have any right to trade any kind of a merchandise good nor barter system, right? So here according to section 8, trading is prohibited under section 8 of a act. So it is going to say that the trading activity of a banking company is completely prohibited. No banking company shall directly or indirectly deal in a buying and selling. So trade means buying and selling of goods or services. It is completely prohibited in terms of a banking company according to Banking Regulation Act, or bartering of goods, right? So it does not have a right to barter the goods. Barter means exchange for the commodity to commodity, except when it is selling a goods kept in a security. So bank, they do have only right to sell the securities. Means, say for an example, a customer, he had kept some kind of securities, gold or a asset in a bank. Means he failed to recover the loan or he failed to recover a debts. So what happens? So the bank have a complete right according to a law to sell his property, to sell his asset or to sell his gold, right? So it have a right. The bank should also not engage in any kind of trade or buy, sell or barter goods. So it does not have any right for the buying and selling of goods and also for the bartering the goods, except a bills of exchange received due to a collection of negotiation, right? So it have only right to trade a bills of exchange according to section 8 rather than bills of exchange, rather than the goods that had deposited. Rather than bills of exchange, it does not have any right to go with any kind of trade activities. According to section 10, that is about management of a banking company. Okay, so this management of a banking company is going to say that a bank should not employ or be employed by a managing partner as stated under section 10 of a Banking Regulation Act. Okay, so a banking company is not going to hire a person as a managing partner, right? Means it is not going to give a job opportunity for the contract basis, right? So it is going to hire a person permanently based on their skills and knowledge, based on certain criteria. And also bank should also not employ a person who has been adjacent, insolvent or whose remuneration depends on the profits of a company. So a banking company, it is not going to employ a person who is insolvent under the court of law, and also he is not at all going to employ a person whose remuneration is depend upon the profits of a company. So he cannot expect a percentage of a profit of a banking company. Hence, this is the criteria for the selection. At least 51% of a banking employees must be a professional experts, right? So according to section 10 of a Banking Regulation Act, it is going to say that, so 51% of the total employees in a banking company, they must be expertised in various streams. So it may be a accountancy, agriculture, rural economy, banking, cooperation, economics, finance, law, small scale industry, etc. Because these are the basic knowledge that is required for a employees of a banking company to communicate with the general public. Say for an example, accountancy. So it is mandatory for the people to maintain or manage all the kinds of the accounts in a banking company. Agriculture. So if they are not aware of agriculture, they could not able to manage banking sector in rural areas. And regarding the rural economy, so they must be aware of a rural economy of the particular geographical location, right? They must be aware of a economic standard and of the particular geographic location where a bank is located. And regarding banking, so what are the functions of banking, duties and responsibility of employees, right? Cooperation and also economics. So they must be aware of economics, whether it is a national or international. And regarding finance, law, so that is about banking law and Indian constitution, and also small scale industries. They must be aware of activities or functions of small scale industries where it is going to benefit for them to offer the loan for the small scale or large scale industries. Means they must be aware of laws that is applicable under a Banking Companies Act. According to the law, they are supposed to act, and in the same way they are supposed to follow some norms that is made by a banking company. A term of office of a director should not be more than 8 years. Means according to section 10, if a person he become a director for a banking company, he cannot be a director under a same banking company not more than 8 years. So after completion of 8th year, he is going to retire as a banking director, and he may placed in some other designations, right? So he may be in the same kind of a bank, but he may be placed in some other designations. Okay, so let us go brief. According to first point, it is going to say that the banking company is not at all going to give a job opportunity for the managing partner. Second point, not going to hire a person who is adjacent and insolvent, and also it is not at all going to give a job opportunity for the person which his salary is depend upon the profit of a company. Means he is not supposed to ask the percentage of a profit of a banking company. And the 51% of a banking employees, they must be aware of a certain general topic that is beneficial for a banking operations. It may be accountancy, agriculture, rural economy, banking, cooperation, economics, finance, law, small scale industries. They must be aware of these all terms which they are going to ask in a banking exams. The term of office of a director should not be more than 8 years. So as a director of a banking company, right, he doesn't have any right to extend his tenure more than 8 years. Within 8 years, he get retired from that particular designation, and he may placed in some other designation in the same banking company. Again, minimum paid up capital and resources. So there are varieties of a banking company had located in a varieties of location. It totally depends upon the where the banking company is all actually located according to section 11, right? So there is a minimum paid up capital. What is this paid up capital is about? See, whatever the amount that the banking company it is going to collect by offering a shares to the public, right? So that we call it as a paid up capital. Banking company that incorporated outside India. So a banking company which is incorporated outside the India, but it is a Indian banking company which is going to follow a Banking Regulation Act. Okay, the minimum paid up capital is 15 lakh rupees. Okay, so please try to understand this term. Okay, a banking company means a affiliate company which is located in a foreign country, but it is an Indian bank. Okay, so its minimum paid up capital is 15 lakh rupees means it is going to offer a 15 lakh rupees worth of share for the general public, and there must be a 15 lakh worth of a paid up capital in a particular bank. So a banking company which is incorporated in India where its branches are in more than one state. So a banking company, if it is incorporated inside India, and also if there is a branches in more than one state, means Karnataka, Andhra Pradesh, Tamil Nadu, more than one state, means a minimum paid up capital is 5 lakh rupees. So if it's a branch as in more than one state, means a paid up capital is 5 lakh rupees. A banking company is incorporated in India, but its branches had established in Bombay and Calcutta. A minimum paid up capital is 10 lakh rupees. Because a population when compared to other state, it is very high when in city of Bombay and Calcutta. So the paid up capital is high when compared to other state. If a banking company is incorporated in India, all the branches are in a single state, right? So according to subsection 2, if a banking company have extend its branches in many states, that is more than one state, the paid up capital was 5 lakh rupees. If a banking company it have all its branches in a single state, that we call it as a banking company which must maintain a minimum paid up capital of 1 lakh rupees. So all the branches are available only in Karnataka, means that we call it as a means all the branches that is available only in Karnataka, that is 1 lakh rupees paid up capital. A company which is incorporated outside India, payment of dividends under section 15, right? A banking company should only pay a dividends for all the capital expenses or paid up. So a banking company, it can only pay the dividend only the capital expenses is paid up. Only if the capital expenses is paid, it can pay the dividend. So what is this dividend is about? So dividend is a reward for the shareholder that is given by a banking company for their investment. Means a dividend is a reward for the shareholder for his investment. It shall not pay a dividends depreciation in a value of investment in approved securities or investments in shares, debentures, bonds are written off. Means it is not at all going to issue the dividend until the calculation of a shares, debentures and the bonds of the company, and also the calculation of a depreciation every year. After the calculation of all the things, so it can issue a debentures for the shareholders. Limitations on nature of subsidiary companies. A banking company should not form a subsidiary company unless the formed company is for undertaking of the business or within permission was obtained for a Reserve Bank of India. Means a banking company, say for an example, a banking company is located in Mysuru, right? So it want to establish its affiliate in Bangalore or any other city. Okay, so until and unless it take a permission from Reserve Bank of India, so it does not have any right to establish a new branch. And also the banking company can hold shares of an amount of more than 30% of a paid up share capital of a company or its own paid up capital. Right? So a banking company, it do have a right to hold a 30% of a paid up capital of a particular branch. Means a head office, it is going to hold a 30% of a paid up capital of a particular branch. According to section 23, opening of new and transfer of existing branches. So according to section 23, it is going to say that so any company, if it want to establish a new branch, any company it want to transfer its branch from one place to another place, or any company it must get registered, or any company that must be established, or any company it want to start a banking business, it must get approved by Reserve Bank of India. Every banking company must obtain a permission of Reserve Bank of India before opening a new branch. So before opening a new branch, it must obtain a permission from Reserve Bank of India as per the norms. Transferring the existing branch to a different city, right? So say for an example, branch is located in Mysuru, it want to shift for a Bangalore, means it have to take the permission from Reserve Bank of India, town or state, whether it is a town or a state level. No banking company incorporated in India shall open a new branch outside India without a permission of Reserve Bank of India, right? So a banking company, it want to open a banking company, it want to globalize itself, right? So it want to open its affiliates in a foreign country, right? It have to take a permission with Reserve Bank of India. However, a new branch can be opened for a temporary period not exceeding 1 month. Means temporarily they can open a new branch. So for a time being of 1 month, it does not have any right to establish a branch not more than 1 month. Accounts and balance sheet. A banking company shall prepare a balance sheet and a profit and loss account on a last day of a working. Means it is going to prepare a profit and loss account and a balance sheet or all the kinds of the financial statement. So it is going to prepare on the last working day. Inspection of a banking company according to section 35. Reserve Bank of India can cause an inspection of a banking company and must state its report to the company. So Reserve Bank of India, they do have a right to conduct an inspection of a banking company once in a year, right? So it is going to see about all the financial transactions. So how the performance is going to happen in a particular branch and how the transaction is going to happen, and also regarding all the operations of a banking company. It is going through inspection. The directors of the banking company must submit all books, accounts, or documents for inspection. So whatever the documents that is required for the inspection that is asked by Reserve Bank of India, it is the obligation of the directors of a particular bank to facilitate them. So while inspecting a banking company, if Reserve Bank of India asks any kind of a document, that may be books of accounts, it may be a balance sheet, it may be a cash flow statement, it may be any kind of a financial statement, right? Or a documents that is relevant for the inspection. So it is the obligation of a directors of a banking company to facilitate to a Reserve Bank of India. According to section 35A, power of Reserve Bank of India to issue directions. So according to section 35A, the Reserve Bank of India, they do have a complete authority to instruct direction. Reserve Bank of India may frequently issue direction to a banking company. So as we know, whatever the instruction that is given by a Reserve Bank of India must followed by all the kinds of banking company, if it is satisfied that the directions are in the interest of a public. Right? So that directions are in a interest or a benefit of a public, or to prevent a banking company from determinately conducted business. So whatever the precautions or whatever the regulations that is made by a Reserve Bank of India, that is a precaution to a banking company and also for the general public to avoid the fraudulent activities that may happen in future. Right? In the next session, as of now, we had covered all the 12 important topics that is in Banking Regulation Act 1949, that is part 2, right? So this is important topic according to a subject banking law and practice. Okay. So in next session, we are going with unit 3, that is Banking Regulation Act 1949. Means in unit 2, we had studied part 1 and part 2 of a Banking Regulation Act 1949. In terms of unit 3, we are going with part 3, 4 and 5 of a Banking Regulation Act, right? So these both units are very important in the final exam point of view. Thank you.